Good afternoon. I'm Jeremy Dawson, the Policy and Program Specialist at NAS. I'd like to welcome everyone to today's webinar entitled Yikes, Amendments to SEC Rule 15c2-12 and Changes to My Continuing Disclosure Agreement. I hope the webinar finds you all well, and I want to thank you all out there for tuning in this afternoon. I'm here to show you how to use the webinar features that we have available. So in your handouts section, you can download the biographies of our speakers as well as the slide deck used today. All audience mics are muted, but we do encourage you to interact with us by typing your questions into the box in the questions section at any time during the presentation. So let's run a quick test, make sure everyone's awake and we're coming through clearly. So if you're able to hear us, please type yes into the questions box. All right, seeing some responses coming through. Perfect. So we do encourage you to use that questions function throughout the presentation as questions arise. Please note that the webinar is being recorded and will be posted to the webinar archive on the NAST site for your future reference. And on behalf of NAST and the State Debt Management Network, I'd like to welcome and thank our speakers for presenting to our membership today and to our attendees for joining us. Mr. Erdman, at this point, I will turn the floor over to you.
Thanks, Jeremy. Again, the NAST State Debt Management Network Webinar Committee welcomes and thanks everyone participating in today's webinar on the recently adopted amendments to SEC Rule 15c2-12, which primarily adds two listed events to the rule. While the compliance date is not until February 27, 2019, many state-level issuers or obligated persons need to start planning now on how they intend to comply with the requirements of these new amendments. The new listed events will likely present some challenges to all issuers. Rather than focusing on events related to specific obligations subject to a continuing disclosure agreement, the new listed events now include any financial obligation of the issuer. A challenge for state-level issuers will be maintaining and expanding, where needed, timely communications and other required oversight so that activities in a state office building on the other side of the state can be reviewed to ensure that any notice requirement underneath SEC Rule 15c2-12 can be filed by the responsible party, which is many of us on the phone today. While the rule does not apply directly to issuers, we all experience the indirect impacts of the rule, especially when an underwriter cannot participate in a competitive sale due to questions on the issuer's compliance with its undertakings under the rule. Today, we are excited to welcome speakers from Hawkins, Delafield, and Wood to walk through the intent, requirements, and applications of these new amendments. Thank you to both John McNally and Ken Roberts for their time in preparing for and leading today's webinar. John McNally is a partner in the Washington, D.C. office of Hawkins, Delafield, and Wood, and past president of the National Association of Bond Lawyers, NABL. John's a frequent speaker regarding application of federal securities law to municipal securities, and other highlights of John's past work with municipal securities is highlighted in the bio that's available in the webinar platform. Ken Roberts is also a partner at Hawkins, Delafield, and Wood, and has over 35 years of experience in a diverse public finance practice involving multiple states and sectors. Ken has received the National Association of State Treasurers 2008 Corporate Affiliate Award for his representation of NAST before the United States Supreme Court in the Kentucky versus Davis case. And Ken has also assisted NAST previously in other industry groups in responding to certain aspects of Dodd-Frank reforms and the development of other standards and laws related to particular public finance programs. Again, thanks to John and Ken for their time today. And with that, I'll turn the presentation over to John.
Thank you very much. What I want to do before we get into the particular amendments is to give a brief overview of Rule 15c2-12. As stated, this is a rule that does not apply directly to you as the issuers, to the governmental entities. It's a rule that applies to the broker-dealers. Rule 15c2-12, dealing with primary disclosure, was first effective in 1989. And then as far as continuing disclosure, came into play in 1995. But when we look to slide 2, we'll see why this is critical for you as issuers. Basically, through this rule, a broker-dealer is advised that if they want to underwrite municipal securities, they cannot do so unless they're comfortable that Rule 15c2-12 is satisfied. And two of the key components of Rule 15c2-12 is, one, before they offer the securities, they have to have received from you, the issuer, what's referred to as a deemed final official statement before they commence the offering. And we know from SEC advice through various letters of interpretation that the SEC considers the use of the preliminary official statement to generally be this deemed final document. And the theory behind that is that the SEC wants to make sure that when the underwriters are pricing these bonds and selling them to the investors, that they're going to be priced to reflect all the then material information, everything that the issuer thinks is appropriate to deem it final. So it can exclude things like the actual pricing information, the actual coupon, the actual interest rate, etc. But all the key material terms are intended to be in there so that they can be accurately priced when they start the offering. So that's Rule 15c2-12b1, and that's a component that's been there since 1989. The other key component is they have to reasonably determine that the issuer, and we can get into obligated person, but basically the issuer has to provide a continuing disclosure agreement, a written undertaking, and that undertaking has to have the issuer agree to provide annual financial information, as well as notice of specified material events. That annual financial information has two key components. One is financial statements, generally which are going to be your audit or your CAFR. And the other is that the annual financial information includes an update to what was in the official statement. And when I say what was in, the phrasing is it's financial information and operating data of the type in the official statement. So basically what's required in these continuing disclosure agreements, that the issuers will be working with underwriters counsel to say, what is in our official statement? What in that official statement can be characterized as financial information or operating data, and that then determines the ongoing annual update. In looking at slide 3, I want to go through some of these key definitions. So, as I mentioned in the first deemed final concept, that is tied to the issuer. The contractual undertaking for the continuing disclosure can be either the issuer or the obligated person. And what do I mean by that? Issuer is the governmental entity that's issuing the securities. And then the obligated person is any person, including the issuer, that's actually securing the bonds through their payments. So as those last two bullets point out, the issuer deems the official statement, but it can be either the issuer or the obligated person that does the continuing disclosure agreement. So why, on slide 4, why was the SEC focused on this? Why did they add these two amendments? Well, what's been experienced in the market the last few years is there's been a lot of alternative financings in the sense of either private placements, for which sometimes there's not disclosure, or bank loans, whereby an issuer will borrow directly from the bank. Now, as a securities law matter, if it's a loan, truly a loan, and we could do another whole webinar on this, but if it's truly a loan and not a security, then the federal securities laws don't apply. We don't have a security. But even if it's not a security, the investors want to know about it. They want to know, is there a financial obligation you've taken on that may be critical to their particular security that they own? And in my perspective on these amendments is, in general, these disclosures are already being made. When you do your official statement, if the working group determines there's a material financial obligation, the payment of which competes with the payment of debt service on the bonds, you're probably going to describe that in your official statement. And in general, the notes to the financial statements are going to describe your key loans and other outstanding securities. So these disclosures in general are being made. The concern of the SEC and concern of the market more generally is that's all well and good in my official statement, but I may be an issuer that's not in market that often. In addition, it can be in the financial statements, but they once again only come out once a year. So the SEC's focus is we want to make sure that at the time you incur this debt, you incur this financial obligation, there's been some kind of default under these instruments, that you then make the notice to the market. This has been going on for a number of years. There's been various advice given by both NABL, GFOA, and others that this should be done on a voluntary basis, but the SEC was concerned it's generally not being done. So the thought was the best vehicle, and really the principal vehicle the SEC has for doing issuer disclosure, is to do it through 15c2-12. And the vehicle then was to say they're going to add 2 events to it to address these points. And at that point, I'll pass it back to my partner, Ken Roberts, to go through the next few slides.
Thank you. And to really understand what the SEC was trying to do with these 2 new events, I think it's important to appreciate a couple of nuances. One, that new issue disclosure really addresses matters that are material to the issue of securities then being marketed, whereas financial statements address matters material to the entity's financial condition. Also, as they noted in the approving release, adopting release, not all obligated persons do make financial statements publicly available, and not all issuers and obligated persons follow the same audit standards. So, in a way, what the SEC was trying to do with the addition of these 2 events was to regularize what disclosures and how disclosures would be made and when they would be made with respect to covered events. So how, and when covered events are to be disclosed for municipal market disclosure purposes. And doing so, this also continues the general trend of developing the MSRB's EMA website as a principal repository of municipal market disclosure, so that there would be one place where potential investors and interested persons can go to access municipal market disclosure. It should be kept in mind that obligated persons who are themselves SEC registrants may also be subject to their own disclosure requirements with respect to certain of the covered events. So we go over to 6, the first of these. And we have a note here that we've emphasized if material. Material here is to be determined from the point of view of the municipal securities that are subject to the continuing disclosure agreement. And the adopting release did state that this was the normal materiality judgment that issuers make in connection with official statement disclosure. So they noted that the standard would be similar to that applicable in the preparation of disclosure generally. The adopting release also alluded, though, to the formulation that disclosure would be material if it would be viewed by a reasonable investor as significantly altering the total mix of information that is available. It's important to note the term material is used twice. I don't think that's accidental. If material applies to both of these clauses, so that a financial obligation is disclosable if it is material to the municipal securities, and its terms are disclosable if they affect the municipal securities being offered in a material way. Two judgments to be made here. If a financial obligation term is disclosable at the time the obligation is incurred, its amendment, if it is amended, may well be disclosable. And more generally, amendments to a financial obligation may require disclosure, even if the initial financial obligation did not. For instance, an amendment to a financial obligation may provide additional security that causes it to be material to municipal securities. So if we could go to the next slide, the other event that was added relates to financial obligations as well, but relates to occurrences with respect to those financial obligations. Default, event of acceleration, termination event, modification, or other similar events, any of which reflect financial difficulties. Again, financial difficulties has to be determined from the point of view of the issuer or obligated person as an entity, or perhaps from the point of view of an enterprise fund or other segregated credit. Modification of terms is clear from the adopting release would include a waiver of a term, does not need to be a permanent amendment as such. So we're talking about a category of things that might be described as monetary default or financial covenant default, or a renegotiation or waiver to avoid such a default. It's been suggested that an issuer or obligated person can safely ignore this, item 16, until and unless it encounters financial difficulties. Given the 10 business day disclosure timeline, that may not be the best idea. It may be proved challenging to identify the trigger provisions that might require disclosure after the fact when and if financial difficulties arise. Most financial covenants are periodically tested, and it should be possible to develop procedures to monitor compliance for disclosure purposes by building on that periodic testing schedule. It had already been the case that an insolvency of an issuer or obligated person had already been a separate material event. So one effect here is to require disclosure on the basis of tripwire provisions, if you will, that private transaction lenders negotiate to alert them of potential financial distress and of responsive actions when one of those is triggered. The adopting release principally addressed paragraph 15, and the way it can be looked at is treating paragraph 16 as a special case, because financial difficulties of an obligated person would very likely be material. Go on to
So before we continue with slide 8, let me just pause and see if the moderator or others may have some questions at this point before we go any further.
Yeah, John, this is Dave. You made reference, and you talked about it briefly, the obligated person. Could you just expand that a little bit? I mean, if I have a bond issue and I have someone who's only paying 10% of the debt service, is that concern me from an obligated person standpoint, or is there some criteria there that defines what an obligated person is?
Yeah, well, the obligated person, there is a definition in 15c2-12, and the obligation, it's defined as any person, including the issuer, who is either generally or through an enterprise fund or account committed by contract or other arrangement to support payment of all or part of the obligations to be sold in the offering. So technically, really any entity who is making payments that would secure the debt service would be an obligated person. Now, what this is generally trying to reach is a situation where you have a conduit financing, you have a governmental issuer that really is simply a pass-through, you do have an obligated person signing whatever, a lease or other loan arrangement, and it's those payments flowing through that are securing the debt service. So what the SEC was trying to reach, that in those cases, the continuing disclosure agreement, the SEC could be signed by the issuer, but the issuer may be reluctant to do that if it's simply a conduit, in which case they allow the continuing disclosure agreement and the burden of that to be done by the obligated person. Similarly, in these new events, in both item 15 and 16, when you look at the slides, they are making reference to the obligated person. Now, recognize obligated person is this broad concept that picks up the issuer as well as the other, it can be the issuer as well as this other entity.
It may be noted that in the proposing release to the 94 amendments that brought this in, there had been the notion of significant obligor being a person who is a source of 20% or more. And the rule is actually adopted, the continuing disclosure provision is actually adopted. The SEC chose not to create a bright line test.
Okay.
Well, chose not to create a bright line test, but also following up on Ken's point, they also chose to go beyond the concept of significant obligor because they wanted to phrase it, once again, obligated person, committed by contract or other arrangement to support the debt service. So it's not simply, is it somebody, let's just say it's a electric revenue bond where there's one corporation that makes a significant amount of the payments for electricity, but if they're not committed by contract to pay the debt service, they're not going to be an obligated person. The SEC, after getting comments, realized that when you're trying to negotiate and write the continuing disclosure agreement, you really have no leverage to go after these entities like an electric company that just happen to be going about their business. But the thought was the obligated person is generally going to be a party at the table who's perhaps the beneficiary of the borrowing. They're committed by contract, and therefore, as part of that negotiation, you can get them to commit to provide the continuing disclosure.
Okay.
So
let's continue with slide 8 then.
Thank you. So let me go to slide 8, and we put up there the language. Now that language, as we mentioned, there have been, initially there were 10 events, there's now 14 events, they're now expanding it to 16 events. The lead-in language by which these events are laid out did not change. And that lead-in language is what we quote in that first bullet. And as Ken was mentioning, it has to be an event that affects the securities of the subject of the particular continuing disclosure agreement. Where I think that's critical is when you're determining the materiality concept, it's not materiality in some broad general sense. It's material, once again, to the holders of the securities that are the subject of the CDA. So it's a subtlety that you keep in mind as we're doing these assessments. So yes, it goes beyond, as we say in that second bullet, it goes beyond, the events go beyond the particular bonds that are in the subject to the CDA, but it has to be material to those bonds. So let me see if I can elaborate a little bit more on that on slide 9. So the difference between 15 and 16 is that 15 is dealing with something new occurring after you've entered into a continuing disclosure agreement. So once again, the compliance date on this is February 27th, 2019. So these events do not have to be included in your agreements. And we don't recommend to include those agreements, those provisions now, because there's no reason to undertake a contractual undertaking before you're obligated to. But because it does deal, at least in 16, with events dealing with any financial obligation. So once again, 15 is dealing with a new incurrence or an amendment sometime after you've executed your continuing disclosure agreement, which generally happens at your settlement. But 16 is saying, if after the closing date you have a default or something similar with respect to any financial obligation, including those that are already in effect, well, that's going to be material, we think, to the bondholders. And therefore, even though that financial obligation was entered into before February 27th, if you have a default regarding that, and that default impacts the bonds which are the subject of the CDA, we think it's an proper time to have a notice there as well. Now, just one more minute on slide 9, you'll see in both 15 and 16 the references to financial obligation, the incurrence, amendment of a financial obligation, or default or similar events with respect to a financial obligation. So what is it? What is a financial obligation? And that's slide 10. So in slide 10, they give us the definition. So once again, these amendments they gave us new 15, new 16, and this new definition. It picks up a debt obligation, which would include, of course, a municipal security. It also basically is any debt-like borrowing. So it's once again those bank loans we spoke about earlier. That's what it's trying to pick up. It picks up a derivative that is tied to a debt obligation, or it picks up a guarantee of either item 1 or 2. That last sentence is somewhat confusing, but we have an interpretation of this. What they said was, yes, a financial obligation is a debt obligation. However, for purposes of whether or not you need to do a filing under item 15, if that municipal security is a subject of an official statement, and that official statement's been provided to the MSRB, then you don't have to separately do a filing for that municipal security under item 15. So once again, 15 says if you have a new financial obligation, you have to do a filing. The definition says, however, if that financial obligation is a municipal security, and you're otherwise providing the official statement to EMA, to the MSRB, you then don't have to do another filing under 15 as a material event. Now, a couple of points on this. One is the SEC advised us, because there were questions from the issuers to the effect, listen, underwriters are under an obligation to provide the official statement to the MSRB. Isn't that enough? The underwriters have the obligation to provide that. Shouldn't that be enough to take it out of the definition? And the SEC said, no, that's not enough. You need to make sure it's in fact filed. It doesn't achieve what we, the SEC, want, simply to impose the obligation on the underwriter if for whatever reason they don't follow through and actually file it. So it has to be filed. But they also told us that whether you file it because you're required to file it as an underwriter, or whether it's filed voluntarily, in either case, we're going to give you the benefit of excluding it from being a financial obligation. But when you looked at this carefully in that last sentence, it says municipal securities to which a final official statement was provided to the OS. So our reading of that, which we explain on slide 11, is let's say you have a derivative. So you have a new bond issue, you have your municipal securities, and it's a municipal security to which you have some sort of derivative or guarantee associated with it. And let's say you have that derivative or guarantee described in the official statement. Our reading of this is and this was clarified at least to some degree in the release, we, the SEC, are going to say you don't have to do a filing for the municipal security, but for these other things that are financial obligations, derivatives, guarantees, etc., a filing is needed for that. So you're in the odd position where you're doing a new bond deal. The underwriter, in fact, files the official statement with EMMA. Therefore, you don't have to do a Item 15 filing for your municipal security, but you do have to do it if one of these other instruments is part of the financing plan, even if described in the official statement. So that's there's a number of areas here where there's going to be questions coming from the industry to the SEC. You know, we hope there'll be some back and forth and seminars where we get clarification on these points. But we think that's the fair reading of what they intended in the release. So let me then pass it back to Ken to further delve in.
A couple questions, John, before we move on. With respect to filing an official statement on EMMA, while not previously required for issuers to do that, you know, some issuers may have done it as a good best practice. Is it safe to say that, you know, going forward, issuers should get into the practice of filing all their official statements on EMMA to make sure the official statement is on file, you know, not relying on the underwriter to do that?
Well, yes and no, in the sense that the underwriters have the obligation to file as opposed to filing it again. I think it would be a matter of the issuers going on to EMMA and verifying that it was in fact filed. And if it was in fact filed, that then fulfills the obligation.
Okay.
Or perhaps getting comfort from the underwriter that it was filed in a timely manner.
I don't think that works. I mean, I think that was frankly, I think that was the kind of thing they were after, which was the issuers were trying to say, the underwriters have the obligation, isn't that sufficient? And I'm not sure even the additional step of the underwriter saying, oh, we truly did it. I think the better course would be for the, and it's easy enough to do, is there's a certain period of time in which the underwriter has to file it. It'd be good for the issuer to verify it was in fact filed. And if that was done, then there's not an obligation under the issuer's continuing disclosure agreement to do an Item 15 filing. If it was not done, then yes, they should file it to meet their 15 obligation.
So as a practical matter, if the issuer is going to undertake to confirm this themselves, and I agree that might be the best thing to do, they will have to undertake to do it a little bit ahead of the deadline, so that if it proves it is not filed, there is time to get it filed.
Okay.
True. True.
And then the other question I had is, you know, with respect to the new listed event 16, you know, a lot of issuers, you know, have bank loans that were in place that as a result of the change in the corporate tax rate, we had new interest rates applied to our bank loans. If we have another change in corporate tax rate that occurs after February 27th, 2019, that causes interest rates to change on bank loans, even if those bank loans were incurred or entered into prior to the compliance date here, that would be an example of something that would be a required filing now underneath listed event 16. Is that a correct statement?
In fact, it is the example of a required filing that the SEC referred to in the adopting release as an example of a term that might be material.
Okay. I know a lot of issuers, you know, wrestled with how to disclose the change in interest rates that did happen, you know, as a result of the corporate tax rate that went into effect back in, late 2017. So this gives a little bit more direction as to what the SEC is expecting, at least from that perspective.
Yes, they're looking in terms, very broadly speaking, but to paraphrase the release, as provisions that may impact upon credit or liquidity.
Okay, sounds good. Ken, I think you're going on with slide 12. If you could just get a little closer to the phone if possible. The last time you were up, you faded off a couple times. We couldn't hear you a couple times.
Okay, so going on to 12, debt obligation. The SEC declined to define debt obligation with particularity, despite a number of comments requesting that. But it did tell us some things about it in the manner of the changes between the proposing and adopting release. There's been an extensive effort in public finance practice and in the law of public finance to define debt for state law purposes. And while it can be assumed that all state law issuer debt would be a debt obligation for purposes of this rule, it's pretty clear the concept is not limited to state law debt. There was substantial comment that was addressed to this particular point as originally proposed. And the main changes between the originally proposed and the adopted rule was to narrow its scope by limiting the scope of leases that would be covered to those that would affect a borrowing, and by eliminating the monetary charges that might result from judicial, administrative, or arbitration proceedings from coverage of the rule. The lease definition is described here as operating only leases that operate as vehicles to borrow money. And that is consonant with the definition of debt obligation, where we quote, circumstances under which an issuer or obligated person has borrowed money. While the adopting release doesn't address this, it seems possible that contracts other than leases that provide for payments with respect to a financing component, as well as with respect to the provision of goods and services, may create a debt obligation. But in thinking about this, and just by way of context, you should keep in mind a general statement made in the adopting release with respect to financial obligations, that financial obligations do not include, I'm going to quote, ordinary financial and operating liabilities incurred in the normal course of business. So I don't think anyone needs to worry about payment in 30 or 60 days. What they are looking for is a borrowing that may be included in another contract. Let's go on to slide 13. So, in this slide, we have a quote that gives some instances of examples of material terms.
A quote from the SEC's release.
From the SEC release, which the listing is not exclusive. Not all of the listed terms would apply in all cases, but issuers and obligated persons should at least consider these points and would, may want to disclose them unless clearly not material. The adopting release does use the tax provision we mentioned before as an example of potential materiality, and other interest rate adjustment terms, such as a yield maintenance term based upon a reserve requirement change applicable to the lender, might also be similarly deemed material. It probably makes sense to take the view that all interest-related terms are material unless they would only have a minor impact. In thinking about the information that should be filed, should consider also at a minimum financial covenants and any payment or lien priority provisions, which are discussed in the adopting release. More generally, in considering what other terms may require disclosure, it would be prudent, absent further guidance, to err on the side of over-inclusion. Let's go on to slide 14. So compliance day, we mentioned the February 27th date. It's worth emphasizing this is on or after February 27th. It seems straightforward. There is a little bit of complexity here. As a general matter, as John mentioned, Rule 15c2-12 treats an offering of municipal securities as beginning on the date when the issuer goes into the market, when the POS is posted. The compliance date for 15 and 16 is an exception to that rule, and we go on to slide 15, please. And as stated in the first bullet here, it is subject itself to an exception. If the preliminary official statement is distributed before compliance date, the actual issuance of the bonds will be afterwards, in which case the POS should attach a form of continuing disclosure agreement. So the exception to the exception is a little bit of a trap for the unwary.
But that will only, to be clear, that will only apply to those limited number of deals that are done where they expect to close. They're going to be in the market before February 27th, but then close thereafter. And I think you're simply saying that you want to advise the investors that you're going to be entering into that agreement in the new form, even though you're in the market prior to it.
Yeah, no, that's exactly right. And most issuers will need to begin incorporating these events in their POS form several weeks before the compliance date to really just the marketing period. But some with lengthy issuance processes, such as a bond validity challenge preemptive period, may have to begin doing that longer before. Have a 60-day preemptive period before bonds are actually issued. You're coming right up on that date. Now, with respect to financial obligations and amendments, the adopting release makes it clear that incurrence, contrast to security, is when an enforceable obligation arises, even if it remains subject to conditions. And for conventional debt, this would seem to be at the time of the bond purchase contract. The negotiation of some private transactions proceeds through a number of stages, and some term sheets or letters of intent purport to be enforceable, may be executed by the parties, may include breakage fees. In the real world, negotiations do take place after such a document is executed. Despite obvious concerns with disclosing the negotiation position and negotiation tolerances, absent further guidance, it may be prudent to treat the first writing that parties intend to be enforceable at the date of incurrence, subsequent modification in the final documentation as an amendment. One practical solution may be to defer execution of a definitive term sheet or letter of intent to shortly before the closing, the actual closing, so within 10 business days of the closing. Let's go on to 16, please. So 16 addresses the issue of a series of obligations, and these may or may not be separately treated for purpose of incurrence date and compliance. The SEC indicated that issuers could rely on the regulations for tax purposes that identify when issues are to be treated separately for this purpose. This again is essentially a transition or day one concern, I think. Although in this instance the date of incurrence could also apply in terms of a post-compliance date, timeliness of filing issue. The caution against structuring to evade paragraph 15 and 16 sort of jumps out as one reads the adopting release, and I think should be taken seriously. It's, I think, worth mentioning, at least in passing, that this raises, at least in my mind, the question of whether an amendment to terms of a financial obligation constitutes a reissuance for tax purposes would be deemed a new occurrence or an amendment for purposes of paragraph 15. And absent further SEC guidance, it may be prudent to treat it as a new occurrence. So there is an amendment which is treated as a reissuance, and probably should be filed as a new occurrence, even if the amendment does not affect a material term. Questions before we go on?
No, very good point there, Ken. As some issuers look at forward delivery transactions in light of alternatives to advance refundings, for example, the state of Wisconsin has a POSL for a forward delivery transaction. If you are going to do that and the forward delivery date is after that February 27th date in 2019, you need to be looking at some, amendments or what your continuing disclosure agreement is going to be now before you publish the POS for that forward delivery transaction. Is that safe to assume?
I think that is the rule.
Yeah. Okay. Interesting. Thanks, Ken. We'll move on to slide 17.
So this is actually John speaking. That was just Ken. Let's go on to slide 17. 17, we're trying to give some guidelines on compliance. So remember that 15 is the one where it's dealing with something new after you've signed your continuing disclosure agreement. Is there a new financial obligation? Has there been some agreement? Has there been some event of default that's occurred? 16 is the one where there's going to be a need for advanced preparation, because 16 says, and once again, this is what's novel about this, is it's a default or an event of acceleration, termination event, or the other ones listed, dealing with existing financial obligations. So you're coming up, it's now, let's just say, March 2019, you've done a new bond issue, you have a CDA that complies with the new provisions. It includes item 15 and 16. You're not simply sitting back and worrying about your annual financial information filing. You're going to be in a position where you've contractually agreed that if something were to happen, as defined in 16, a default, let's say, to any of your outstanding financial obligations as defined, you have to undertake an agreement to provide notice to the market of that. So our recommendation to the issuers is you should begin well in advance of February 27th to get a sense, to catalog what are our existing financial obligations, such that were there to be a default or an acceleration or a termination event under them, in order to comply with our contractual obligation, we are going to file a notice. We need to have a sense of what's out there, what would trigger it, and be ready to file it in a timely manner, not in excess of the 10 business days. Now, I think I mentioned when we started that the SEC's perspective on this is it's really dealing with trying to achieve transparency. In general, these financial obligations are going to be in your official statement if they're material. They're going to be in your notes to your financial statements. So if you're now doing what we're recommending, which is establishing a cataloging of your financial obligations, one place, at least as a starting point, is your audited financial statements. Because GASB 88, which comes into play came into play June 30, 2018, GASB 34, when you look to your notes, you'll see a listing of your outstanding debt-like instruments. So at least that's a place to get started. But the SEC cautions that mere compliance with your accounting guidelines, your notes, is not going to be sufficient, but at least a place to start. The other item of some sensitivity here is you're dealing with old agreements, existing agreements, which may have in their terms an understanding that you will not disclose X, Y, or Z. So how does that impact compliance going forward with paragraph 16. That's something that the market's going to have to resolve sometime between now and February 27th. I certainly think that, for new agreements that you may be entering into, you may want to negotiate an exception to what otherwise may be a broad non-disclosure agreement. But to the extent you have such non-disclosure agreements, already just you need to be careful about how that dovetails with any obligation you undertake to comply with item 16. The other thing we want to note, I'm now actually up to slide 19, is, and this is more general, it's really been the case for the last number of years, that the SEC in their enforcement proceedings has been recommending that issuers at all levels, state level, local level, have written controls and procedures and have periodic training to those procedures. And what that achieves is a defense in some sense. So if you're a corporate issuer and you have a material misstatement, and whether it's through negligence or recklessness or whatever, under the securities laws, you now have no defense to that. The issuer doesn't. The other parties do. The underwriters have the due diligence, as do some of the other parties, but the issuer has liability. When you switch over to municipal issuers like yourselves, state issuers, you're not subject to that provision of the securities laws, which only applies to registered companies. The SEC still has to prove negligence. So our recommendation away from these particular new amendments is that you do have written disclosure controls and procedures and periodic training so that we're there. In the first instance, it should help to improve the quality of disclosure and hopefully avoid making any mistakes. But equally importantly, if there were to be a mistake, and you've done exactly what the SEC recommends, then it's a very solid defense to potential liability. And I can tell you, I've worked with a number of issuers, not only where we've established these, but others where they had them, and they were in fact able, despite making disclosure mistakes, where the SEC conducted an investigation. But having seen they had the procedures, having seen they had the trainings, decided, well, there's nothing to be particularly gained here. It was a legitimate oversight. We're not going to bring the investigation. So it's good practice to have it. If you don't have it, you should. But even if you do have it, they need to be dusted off and looked at to make sure that you're going to be able to comply with these new items 15 and 16, particularly dealing with that item of cataloging what you already have in existence. And here's where there's going to be some pressure from the underwriters, if you will. So remember, when we first started, we mentioned that the underwriters have the obligation under Section B5 of 15c2-12. They have to reasonably determine that you're going to comply with your continuing disclosure agreements going forward. The underwriters are going to be asking for deals that they underwrite after February 27th. Dear issuer, have you cataloged your existing financial obligations? Dear issuer, are you at a point where were there something to occur shortly after the closing, you're in a position that you can give us comfort that you can file in a timely manner? So these amendments have just come out. We have until February 27th for the very reason the market understands, the SEC understands. It's going to take some time to comply. But the prudent course is to start so that when the underwriter says to you, do you have a cataloging, do you have procedures, it allows them to reach the reasonable determination that you will in fact comply going forward. So that finishes. I'll send it back to Ken for some of the concluding remarks. But I think that's the heart of the advice: is to have the procedures, to have the training, and at this juncture, recognize the importance of these two new amendments and the need to get a handle on what particular obligations you may have that you didn't have before, post February 27th.
Okay, going on to our last slide, 20. So we've talked about most of this. Community disclosure agreements will need to reflect these amendments. Issuers who do deals where there are other obligated persons typically have contractual rights to require disclosure through loan agreements or leases with those persons, and really should review their contractual provisions to make sure that these new obligations flow through those. We talked about bond purchase agreements previously. Issuers may want to require a contractual obligation to file disclosure of official statements that might otherwise be exempt through EMA in a manner consistent with the rule, and to do so in order to establish an exception from these. Underwriters, as John just said, are required to have reasonable procedures in place, and can be expected to attempt to address this through diligence and perhaps also through additional certifications at sale or closing from issuers and obligated persons. Some borrowers in conduit deals who have been willing to undertake 15c2-12 disclosure as obligated persons may be reluctant to do so. And I think in general, issuers should anticipate that they will need to educate other obligated persons on their transactions that are not themselves municipal issuers as to these new requirements, and to address concerns that are legitimate concerns that they may have with respect to the confidentiality of their private deals that might require a disclosure, and for obligated persons who are themselves registrants with the SEC, concerns about coordination of their disclosure under their securities disclosure regimen and disclosure under these rules. A couple of general points. It is, again, just to emphasize, I think we said this earlier, that it is possible that interpretive guidance may be forthcoming by the compliance day, although certain of the how to do it concerns will doubtless be worked out over time, probably after that date. Issuers with multiple financing programs may be in a position where they need to consider some of these points, particularly for materiality, separately. In other words, if there are separate credits, what is material to a revenue bond may not be material to a GO bond. And just to emphasize a point made before, larger issuers who have are in large organizations will need to address organizational concerns in terms of assuring that the individuals who are responsible for this 15c2-12 disclosure we've been discussing have timely access to events that may trigger disclosure requirements, even if they don't have other responsibilities with respect to privately placed debt or other contracts that may constitute borrowings. I think we'll turn it over for questions.
Well, let me also note, just before we do finish this, that Hawkins does advisories to clients. We did one on August 22nd, shortly after the SEC published the release. We've had the benefit of a number of conversations, attending and speaking at a number of conferences since then, where there's been additional questions come up, and we sent out just yesterday what we call a compliance alert. And we're happy to send this to the folks at NAST, and they can in turn forward it on to anyone that might find it useful. To give you a sense of it, it only runs, thankfully, the total of the 2 advisories only runs 4 pages. So I think it's a good little thing to keep close by, because it does, frankly, provide a good summary.
Might have saved them an hour by offering that at the top of the session.
Well, that's why I waited till now.
Well, thanks, John. Thanks, Ken. And yeah, if you could provide that, we'll get that around to the people that are participating in the call. I guess, very good topic. I think each issuer, probably should reach out to their respective bond or disclosure counsel if they haven't already, and start the process as to how they're going to comply with these new amendments that were adopted to 15c2-12. You mentioned you expect additional interpretive guidance. I think at the recent NABL conference, the SEC announced that they're going to have a Muni conference on December 6th. Do you expect anything enlightening to come from that Muni conference on December 6th that, could help address any of the open questions on these new amendments to 15c2-12?
I think it'll take, just by way of background, when the SEC came out with their amendments to continuing disclosure back in 94, 95, there were a series of what were called Q&As that went back and forth. So there were two really significant letters that the SEC came out with where they answered, I think it was in the neighborhood of like 25 separate questions. In addition, with their municipal advisor guidelines, municipal advisor regulations, they ended up doing 2 sets of Q&A. I think that'll eventually be the vehicle by which they'll give additional guidance to the market. The December 6th is considerably broader. It's really their attempt to have a general meeting with market participants to see, what are the critical issues out there? What should we, the SEC, be addressing? How can we do it better, et cetera? So it's not going to be focused uniquely on this. I really do think there'll be, my best guess is there'll be some kind of Q&A coming out to address the questions, because as we go through it, and as we work our way through the deals we're working on, questions naturally arise. I mean, they came up, frankly, even in a course of putting together our compliance work just went out this week. And the SEC in the past has been pretty cooperative in trying to get that guidance.
Yeah, that said, the Q&A experience that John's alluding to took place over a period of time, and I think it will take some weeks, if not months, to really get clarity on some of these points. And also, the world of private transactions is fairly complex and various. So things will arise as people attempt to work with these rules. And I think the SEC will probably find that there are a number of judgment calls that people are looking for help with.
Okay. No, that's good information. Again, if anyone has any questions, feel free to submit them on the question tab in the webinar. Again, as I mentioned, I think it's really important for all issuers to reach out to their respective bond and disclosure counsel and start discussing, how they're going to move forward with compliance on these amendments. A lot of good information in this webinar. We're all state issuers, and unfortunately, we're responsible for disclosure of a lot of activities that happen in a pretty wide area. And identifying, as was mentioned in the presentation, identifying, contracts or other financial obligations that could trigger events is going to be a key thing for issuers at the state level to complete, to have that checklist, have that inventory of agreements out there that we can quickly refer to and have communications in place so we can receive any changes that occur to those contracts. With that, seeing no further questions, I think we'll call it a wrap. Again, thanks, John and Ken, for your time preparing and presenting a great webinar. Thanks to all the participants that dialed in and participated. If you have any further questions after we get done, feel free to reach out to us. If needed, a follow-up webinar can be organized on this topic. Looking ahead to future webinar topics from the NASS State Debt Management Committee, we do have a tentative hold for a webinar on Friday, November 2nd, in which MSRB, Emma will walk through their recent upgrades from an issuer's perspective to the Emma system. And then we're also hoping to have another webinar before the end of the calendar year to address another topic that's going to be important to all state-level issuers. That's the pending conversion of LIBOR to SOFR. So with that, again, thanks everybody. Thanks, Ken and John, for your time especially, and we'll talk at the next webinar.
Well, thanks for allowing us to do this. Thank you.
Thank you.